Yeah, please, your lordships.
Yes.
With regard to item number 11 of today's list matter, it relates to POXO matter. On the last occasion, on the report of the OC, your lordship had deemed it that the service of notice on the informant was complete, but nobody has appeared. So amicus has to be appointed in that matter before the hearing can be conducted.
We'll pass the order.
Yes.
After the orders, when the matter reaches.
My lord, I need to mention in respect to item number 12, your lordship. 12.
Yes.
The matter may kindly pass over, my lord,
You are for the
appellant.
appellant. Why do you want it passed over?
Some personal difficulty.
Personal difficulty suddenly came up. See, there's a system in place, circulation of adjournment sleep. Item 14 to 17, 16, they have been circulated. You could have done that same thing. What about the other side? PP,
My lord.
any objection?
Oh, yes.
And the prayer of Mr. A. Raman, learned counsel for the stands passed over. Got it.
May I
Master,
please, I beg to mention item number 14, 15 and 16, my lord.
17.
I am for 17. I am for 17.
you are the one who circulated.
Yes, yes.
You missed 17. Till 17, they're together.
Yes, yes, my lord. I'm sure.
I am 17.
He's
So any
proper-
objection?
Yes.
Any objection?
No, boss.
When do you want it? After vacation. You are Mr.
D. Bora, my.
And he?
D. Bora, my.
Item 17.
D. Bora.
Yes, my. I am for item number 14, 15 and 16, my lord.
Mr. D. Bora, learned counsel for the appellate. These matters, except for criminal appeal number 211 of 2022. Submits that as he has some procedure. He prays that the matter will sit after the next week. So, Mr. N.J. Gogo, learned counsel, will pray for the appellant in item in criminal appeal number 211 of 2024. Also submits that since the matter is clubbed together with the other appeals, he has no objection to the prayer for adjournment. Likewise, Mr. R. Kaushik, learned state counsel. Learned additional PP, paying for the state. Has no objection to the prayer. When I spread for this matter, let's see publication. On a date to be fixed by registry.
May I please? My lord, kindly, regarding the item number 5, my lord, kindly fix another date, my lord. My lord, today morning I have received the brief, my lord, with NOC of the earlier engaged counsel, my lord. So please kindly fix another date, my lord. Item number 5
Your name is here shown.
from Azizul Haq, appellant.
Sorry,
Azizul Haq, for Azizul Haq, appellant.
for the appellant.
Yes,
You're taking over from Mr. Chaudhary.
yes, yes.
M.K. Chaudhary.
Yeah, I have received already NOC, my lord. That's all the thing.
Well, then your
Today-
power,
today.
when you will file your power?
Today morning, my lord.
You have filed.
Yes, my lord. Oakland already filed, my lord. That is
Mr.
why, my lord, I pray, my lord, fix another date, my lord.
Mr. Azizul Haq,
Yes, my lord, yes.
learned counsel, submits that he is the newly engaged counsel for the appellant. And he has also obtained NOC from the earlier counsels. Appearing for the appellant. Stop. He submits that since he has received the brief recently, he would like to prepare the matter for which he seeks another date. What about the respondent? There's no name shown.
Ajit.
We'll give the file. Item 5.
Namely Tanuja Khatam. This one name is Tanuja Khatam.
See, there's no office. Office door. You posted after 2 weeks or after the vacation?
Before vacation, my lord, kindly.
Before,
Before vacation.
but you have to take steps. Respondent have not appeared so far, so you have to take steps. You have to take steps. In view of above, let's this matter. Give a date before the vacation. On 22/6/2026. The appellant shall take steps for service of notice on the respondent. In terms of the order dated 24/20/2026. I repeat, 24/20/2026. Within 3 days.
All right.
May I please, your lordship? Pray
Yes.
for listing of a CRP IO, your lordship, on this Friday.
IO, what is IO?
Your lordship, it's the order of the family court. Your Honor, the Learned Family Court has rejected an application for amendment of the WS, your lordship. We have filed a CRP against it, so it has been referred to the division bench, your lordship, since it's a family court matter.
But what is IO? You say IO.
IO is an interlocutory order, your lordship. It's been registered as a CRP IO.
CRP against IO.
Yes, your lordship.
We'll have it next week, perhaps. 17th.
Lordship, the matter is fixed on 20th before the trial court for cross-examination.
17 is before 20.
Lordship, I make the mention for listing of criminal appeal, Lordship, and it was earlier listed in the year of January 2025, Lordship, last posted, Lordship. It was
What kind of appeal is that?
appeal against conviction, Lordship. He was convicted under section 6 of POCSO Act for 20 years, Lordship,
You want it to be listed for?
for suspension of sentence, Lordship.
Aye.
Interlocutory application is pending, Lordship.
Give a date. IA.
Lordship. And another
And,
prayer, Lordship, it was
Just a minute, just a minute. We are not allowed yet. IA means for suspension of
for
sentence.
suspension of sentence.
Is there an objection filed by the state?
Lordship, last occasion, Lordship, the prosecution take times, Lordship, to file their objection. Lordship.
So is it filed or not?
Not yet.
Not
filed.
yet filed. So if we get it listed, they'll seek time again.
Lordship, any date next week, Lordship.
IA. You want before vacation,
Before vacation, Lordship, any date, Lordship.
23/6.
23, Lordship. Deeply honored,
You intimate your friend, Mr. Kaushik also,
Lordship,
so that he can also, file a W in the meantime. What case you are mentioning?
Lordship.
Tell him.
Deeply honored.
May it please your lordship. My lord, this is a matrimonial appeal. My lord, today I have a prayer. My client says if the husband paid my lord 15 lakhs, then she is ready to compromise. And otherwise, earlier the matter was sent for mediation. Then we said that we want 20 lakhs. That he has not agreed, my lord. Now she has come down to 15 lakhs, my lord. One prayer. Another is, my lord, if he is not agreeable, then matter will be hard and disposal. I am for the wife. Yes. I am for the wife. Yes. I will accept 15 lakhs, my lord.
15 lakhs as a one-time payment.
Yes.
permanent element.
Element.
Any instructions to that effect?
I have instruction that he will receive his pensionary benefit near about 13 lakhs to 15 lakhs. only. So that is his own, because rest of the amount will be settled with his loan account. So his proposal was that she is having a house constructed by the husband over 1.5 lakhs of land with a G plus ground plus 2 foundation building. It is around 80 lakhs valuation. So he is ready to give that land and house to to his wife. Besides that, he cannot pay. Otherwise, he is paying 10,000 rupees to the daughter also. And 8,000 rupees to the daughter and 10,000 rupees to the son and his wife. 18,000 he already been paying. And he will receive pension as per his instruction, 30 to 35,000. It is not possible on his part to pay 15 lakhs.
The house, and
House is in my lord government land. It is not so much valuable.
who is staying there?
Wife is staying there with children.
But
Yes. May I submit
She is
one?
staying there. It is a small house, my lord.
Sell it and give her the money.
He is ready.
She is not selling.
No.
Where she will go?
Some share in it.
Where she will go? If the property is.
You have to
still-
propose that also. Say, let's sell it. You will
Where's
take half
he?
of the amount I will take. And he is also not having any permanent accommodation also. He is staying in the rented house. May I propose one thing? That the maintenance matter may be decided by the family court. Because by the judgment also, the part of maintenance has been kept open. So, and in fact, before granting the permanent alimony, the family court can also calculate the assets and liabilities on the part of both the parties. So within a time frame, that may be decided.
Which order has been challenged in this appeal?
My lord, divorce order.
Divorce order
Divorce only.
filed by the husband.
Maintenance part is not there,
Maintenance part has been
it
kept open.
my lord.
kept open.
Kept open.
Then I pray matter be hard, my lord. Matter be hard. Matter be hard. And then family court will decide. She will file application for permanent alimony. Then matter be hard, my lord.
No, regarding maintenance part, what do you say? Should it be go back or maintenance?
I will go back after decision of this honorable court. If this court set aside the divorce order, then why should I go for maintenance? I have, sir, lordship, daughter marriageable age, my lord, and my son is studying, taking loan from the bank. So I have liability.
Okay.
Daughter marriage is expensive, my lord.
Oh, we post matter for hearing that. What do you say?
It's a very short date maybe
That much.
because he retired and on their objection, the pension and all has been halted.
You're married again?
Not
You're married again? Remarried,
as per his instruction, not.
not remarried. So why is the pension has
As per
been held?
my instruction, he married
Why is the,
and having a son also.
let's see, why is the pension withheld?
On their objection,
Pension must be given, pensionary benefits, other benefits are with it,
all has been halted.
but the pension,
No, nothing has been.
Pension
mother
दिसे नहीं,
को-
pension दिसे पर, pension दिसे. Pensionary benefit में भी होता pension. Pension.
Retired in the month of February.
not even started.
Yes, any date?
19/6.
For hearing.
For hearing? Learned, the parties are represented by the respective councils. They submit that the matter was sent for mediation, but mediation has failed. Stop there. They will submit that the matter may be taken up for hearing at the earliest. Considering the same, the straightforward is the matter on 19th June 2026 for hearing.
Matul.
Much.
May I please announce? There's an appeal against and conviction. The paper book is ready. I have checked the office note.
You have
but
received?
I have not received it.
We have also not received, my lord.
The appellant and the respondent number 2, amicus, but the state has received.
First list is PB2, so we don't have any extra. No extra. Then how they will argue? Only two papers are prepared, two paper books. Receive a copy of paper book in connection with criminal appeals from sent on behalf of the learned PP. PP has received. PP has received, one sheet is there. Others?
Amicus, we have also not received, my lord. Perhaps lordship may direct to furnish copy to us first and then fix it for hearing.
Can you share the PDF copy amongst yourselves? Can you share the PDF copy of the appeal? You share? Oh.
We can. Little quicker, please. It goes back to the registry, comes down another month or two. So share copies and you need to go by.
All right, is the copy taken?
Yes, we can
copy my.
Also, anyway, it is ready, so a Xerox copy can be directed to be made by the registry also, because anyway, it's not gonna list this week. It has come up for orders, it will come up for hearing. Or I can take a Xerox copy from my friend, anything, the lordship.
How many pages are there in your copy?
279.
Somehow this looks thicker than that.
Yes.
That is both sides.
Mine
Yes,
is
yes,
both side.
That is right.
That's- So you'll take photocopy from him?
If lordship directs, yes, lordship.
Any difficulty?
No difficulty.
Because we are asking the registry to prepare paper books in many cases.
Lordship.
At least if you can arrange that
Lordship.
amongst yourself.
Sure.
Okay. It is seen that the paper book is ready, but only a copy of has been furnished to the learned public prosecutor. To stop the learned counsel for the appellant as well as the respondent number 2. Submit that they will take a photocopy from the learned public prosecutor. And also pray that, and they also pray that the date may be fixed for hearing the appeal. We have list the matter. The date after the vacation?
After vacation.
On 28/7/2026 for hearing.
Deeply applied.
May I please, my lord? Lordships, as per the last order, the learned PP was supposed to furnish the information on service on respondent number 2.
Information not yet received, madam. That is number 3. Not yet received.
How much time you got?
My lord, before vacation, any date, madam, or next week also.
TCR has come.
Yes, lordship.
TCO come.
So meanwhile, I think they can prepare the paper book.
Yes.
Yes, lordship.
Notice on respondent number 2 is yet to be effected. Stop Mr. R.R. Kaushik, learned additional PP, Assam, pays for further time to inform the court about the status of the notice to respondent number 2. Stop in view of above, list this matter again. On so and so, give a date on 18/6/2026. In the meantime, the registry may start the preparation of the paper book since TCRs are arrived.
Your best, my lord.
May it please your lordship.
Yes.
Your lordship, in this matter, as per the office note dated 5/6/26, the TCR perhaps has not been received. Your lordship, may kindly direct the registry to take steps to call for the TCR.
Regarding service also, I have not seen any note, my lord. Perhaps has not been taken. Yes, madam. Yes, we.
So let the TCR come,
Come.
then we'll. Think. It is seen that the TCR has not come, has not been sent till now. Wish to send a reminder to the trial court concerned for sending the same immediately. Stop once the TCR is received, court may consider issuing notice to the respondent number 2 bracket informant. Next matter, list again immediately on receipt of TC.
Deep leverage.
May it please, my lord. My lord, TCR was called for, my lord, and I have checked the records. There is a letter from the learned trial court marked as letter J, my lord. It says that TCR has been sent, but it is tagged with some other appeal, my lord. The blue flag, my lord.
It's a common judgment. Over.
Accused was there, my lord. My lord, we have in terms of order dated 30/3/2026, my lord, and Office of the Learned PP, my lord, they have acknowledged, they have given this acknowledgement that they have sent to the officer in charge of Barpeta Police Station.
Okay.
On the first date itself, my lord.
On 8/5 itself.
It's got 8/5, they have sent, my lord.
You have taken steps?
Lordship, I have.
When? It is not indicated here.
Yes, my lord, it's not indicated on the last day also. We have taken, we had taken on 31st March, my lord. Through PP, my lord. Through the office of PP. This is our email receipt, my lord. And from the office of the PP, they have sent on 8th of May to the OC.
That regarding, we have signed on 8 May, my lord, regarding service that report yet not received. Regarding this PCR, I think there is some mistake because there is, I have seen, my lord, there is only one account.
Yes, my lord.
So that PCR,
POCSO case number 109 of 24, isn't it?
yes.
But this also is special POCSO case 109. So mistake is at on which part? Trial judge.
Maybe, my lord, because here.
There cannot be two common numbers for a case.
Yes.
What is judgment actually? 1/0/24. 1/0/24. Okay. One question. Please write down. TCR was called from the trial court concerned. But the trial court has written back to the registry by communication dated 28/4/2026 bracket black Z, those bracket, that the TCR has already been sent to the registry in connection with memo number HC dash Roman 24 slash 253 slash criminal appeal dated 1/4/2026. Of considering the same. The criminal appeal of president. Let the matter be listed again along with criminal appeal number 253 of this case be listed along with the criminal appeal, wherein the memo number was shown as HC Roman 24 slash 253 slash criminal appeal dated 1/4/2026. So as to sort out, to sort out the confusion. Please be matter. Wait. Vacation. After the vacation, on a date to meet by the learned public, additional public prosecutors should also inform the court about the status of the notice sent to respond number 2 by the next day.
Obliged.
Yes, Your Lordship, the paper book is ready, Your Lordship. Kindly fix the matter for hearing. In the meantime, I'll collect the paper book. Okay. Collect the paper
Please write. Is it
One book of paper, no? Or to the judge.
parties are represented by the respective councils and they submit that they have received the paper book. I pray that the matter be listed for hearing. Your registry to list the matter for hearing as by its own time.
Yeah, after vacation.
After the vacation. So we need
Obliged.
like this.
My lord, may peruse order dated 29/4/2026.
Right, you're Mr. Prasad. Mr. P. Prasad Learned, amicus curiae appears for the appellant. While Miss. Madam, you kindly, your name, please.
A Begum Lucky.
A. Begum. Learned additional PP. Appears for the state. Stop non appears for the respondent of the bracket complainant despite service of notice. Stop under this circumstance, we deem it proper. We deem appropriate to appoint. May very permanent as the learned amicus curiae to represent the respondent of the registry shall furnish her copy of the paper in 3 working days. This is the matter for hearing. Uh, After the vacation on the date to be fixed by the registry.
Lordship, I pray for time being. Senior counsel is in another court.
Who's the senior counsel?
My lord, senior counsel is at command.
What sort of case is this? Is it a total?
After vacation only. After vacation only, Lordship, the senior counsel will take time, Lordship. Case is going on regarding
Siddharth Sharma.
Siddharth Sharma, Lordship. Jubin case is going. So it will take.
So everybody has gone there. What will we do? So you suggest when do you want it?
My lord, let it be after vacation now.
Registry will fix a date.
Registry.
Mr. Ajay Kamath, learned senior counsel appearing for the appellant is said to be on legs in a different court. And it is submitted that the matter would take some time. Stop considering the same and as agreed to by the parties, list this matter after the ensuing submission on a date to be fixed by notice.
Lordship, may a date be fixed and after vacation, my lord? Because this is an engaged matter in which senior counsel has been engaged and although,
But do you have the dates?
my lord, any day,
Do you have the agreeable date?
my lord,
If you take one date, he may again say that I'm not available on that date.
my lord, then let the registry. Obliged.
May I please the lordship?
Yes.
My lord, this is a case of irretrievable breakdown of marriage. They are separate from each other for the last 22 years. There is a major boy belonging to them, who is now major. So, divorce may be allowed.
Order with 2013.
Yes, my lord, but delay, my lord, if I prefer delay application, then come down.
At least you are not there. That's
My lord, yeah, in this matter, the counseling is taken twice, my lord.
but the counseling failed, my lord, and
They don't want to stay together.
still, my lord, my telephone instruction from my client, my lord, from wife, my lord, the wife said that, my lord, if the appellant assured dignified dignity life, then she's still ready with her son to stay with their husband, my lord. Yes, yes.
He is not ready, therefore he is proposed for
Then, my lord,
making an appeal.
then, my lord, done alternative arrangements in, my lord, admittedly, my lord, my husband, my lord, he is the government employee, my lord, he's doing service, is the service till 2029, and I'm staying in the rented house with my son, my lord. I'm receiving
Separation, 2013.
13.
Allegation is that the marriage is in 2002.
13 decreed in my favor, my lord.
That's one from
Then
2004.
2018, my lord, restitution conjugal file, this is also dismissed, my lord.
Even you don't have a restitution, you don't have a divorce. You have a major son.
Major son, he is just, passed BSc, my lord, just 3 years.
How long does it?
Therefore, some alternatives, my lord, yes.
Sustenance of life.
Yes,
There are other procedures in law you can have it,
yes, my lord.
but another good. You will seal upon marriage on you.
Admittedly, my lord, there is a long gap, my lord, it is true.
Continue from 2000, at least 13 million you are not staying together after this.
No,
order.
no, not to say,
So that is at least 12 years from.
my
Means in life.
that's my lord.
What means in life? You can't even go to Teeth Yatra now. Because the litigation is pending, isn't it? Somebody is pending.
Yeah, because definitely, but everyone has a, even petitioner also have the right.
Either we allow the namesake seal to remain, we are married. Or I would like.
Even my son,
Whatever, this thing you need, whatever. Survivability, whatever you need, whatever is that to provide.
yes, my lord.
Otherwise, I will not let you go. It will.
Yes, my lord. My lord, there's things I also yeah.
Will open.
I also talked to my client in this regards, my lord. Since nothing remains in this regard, since long gap between the parties, my lord, you're just, so, my lord,
Let's take some responsibility.
my lord, in this regards, my lord, certain guidelines, my lord, I like to place, my lord, honorable apex court decide on this point specifically. Yes, my lord.
My lord,
Yes.
From him.
Yes,
my lord, they are getting the maintenance,
What is the amount?
10,000 per month. Now
He-
she is single.
Huh?
Now she is single since the boy is major.
Ah,
So she is alone is
he's a
getting.
graduate. He's a graduate.
Yes.
Graduate children need some maintenance. That has to come from the mother. So if you increase it for the mother, she can maintain the son also significantly.
Still I am paying rupees 10,000 per month. Regularly I am
You
paying.
are a government employee.
Oh, LP school teacher.
Teacher.
Teacher now only part of his retirement.
Settle for one amount. Offer an amount.
That I have no instruction on it.
Huh?
I cannot give assurance on the amount of permanent alimony.
Permanent alimony.
So
Promise something.
This may be decided by the court below, by inappropriate proceeding. Here I am only for the divorce. Here I am only for the divorce.
Your divorce has been rejected. Restitution of conjugal rights has been rejected.
Rejected. So where I am to go? Now the Supreme Court decision has come regarding irretrievable background of marriage.
Is it possible for us to do so?
Yes.
Is it possible for us to do so? Or does the power remain with the Supreme Court to do so?
That I have
That
seen,
ground can we give us this?
that I have seen, my lord, but your lordships are now in a position to allow the appeal. There are several meditations that failed.
Evidence is that you have refused to take back the wife, evidence all against you.
It is there, but I say that I have been deserted.
why don't you consider send the matter for mediation?
In addition, my lord, first of all, we did a proposal regarding to stay together, my lord. He rejected, he not, then we proposed they give us some shelter, some protection residence in, so that we could, with my son, I could stay, my lord. I'm staying in the rented house, 10,000 I'm paying, and he's paying to me.
No,
Even
It was already sent to mediation earlier,
Yes,
twice,
yes,
twice, my lord,
twice.
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 Twice failed me,
Any
lord.
record,
That failed.
any records here that it was sent for mediation? On which, okay. Mediation report. See, it's too late in a day for you to say that I'll go back and, like, we'll read it together.
Yes,
So much time has lapsed.
yes, my lord.
And for him also, just to challenge the rejection of the family court's order, he might not get any benefit also. That is why, like my brother pointed out, if both parties can come to some agreement, give us some amount, let her have her own life, you have your own life. Did you talk to your respective clients in that manner?
I have no instruction regarding the permanent alimony.
Why don't you make an attempt?
We made several attempts, but we are regularly paying the maintenance allowance of 10,000. This may be increased to some extent. I fairly submit.
We want a complete severance of the relationship.
Yes,
Then why keep paying monthly even after the matter is severe?
that is
We
true.
allow.
That is true, my lord.
We increase the maintenance and we secure the relationship. Even then we keep paying her. Pay her at a go. Let the severance be complete.
Yes. But the amount that they are demanding, my lord, it
The
is,
elephant will pass through the middle hole and only the tail will remain.
yes,
Why let the tail remain? It will also pass through.
that is true,
The
my
entire
lord.
elephant has gone.
That is true. But
Have you instructions on a permanent element
yes,
to be offered?
he is already said that this man is already saying that he is able to pay with 4 lakhs at a time. More, cannot do more than that.
He is a government teacher or a private school?
Government teacher,
Government school teacher.
But in
LP
the-
school, government school teacher.
government, school, but in the lower primary sector,
Ah,
My lord, he's
lower
the-
primary schools and upper primary.
LP, lower primary,
Huh?
lower primary.
File your assets and liabilities.
Yes, it is better, my lord.
File your assets and liabilities.
Yes, my lord, it's better. It is Rajni's
Then
case, my lord.
propose an element. Give us your assets and liabilities on affidavit. Then tell us this is the alimony I can provide.
Yes.
Let us have a their
Yes,
stand on
my
it,
lord.
we can file it.
Yes, my lord.
2 weeks time maybe in that. So this may come after vacation. After vacation, this may come. I'll file a video.
Appellant is 50 years old. Pretty. Family school. Third, Mr. Your good name, please.
NH Malawi.
NH Major Bhuyan,
Yes.
learned counsel for the appellant, and Mr. PK Deka, learned counsel for the respondent. Stop. This is a matrimonial appeal filed by the appellant bracket husband against the judgment dated 2/5/2013 rendered by the principal judge family court Kachar Silchar in FC bracket civil number 119 of 2008, by which the degree of divorce sought by the appellant was rejected. It is submitted at the bar that since the year 2013, the rival parties have been living separately. Stop. A son born out of the marriage has now graduated and has attained the age of majority. Stop. According to the appellant, he has been paying monthly maintenance of rupees 10,000 per month to the respondent wife. Stop. The learned counsel for the appellant submits that since the parties have been living separately for so many years now, the degree of divorce rejected by the learned family court should be set aside, and the appellant should be given a degree of divorce. Stop. Mr. PK Deka, learned counsel for the respondent, submits that as per instructions received by him, the respondent, even till date, is willing to live with the appellant in a dignified manner. Stop. He, however, submits that it is a fact that the parties have been living separately for a long time now. Next para. It is also noticed that matter was sent for mediation, but the same has also failed. Next para. Considering the interest of the parties concerned, as well as not as well as under the facts and circumstances. Considering the interest of the parties concerned under the facts and circumstances of the case, we deem it appropriate to direct the appellant to file an affidavit, to file his assets and liabilities by way of an affidavit within a period of 2 weeks from today. Stop. The learned counsel for the appellant shall also obtain necessary instructions from his client with regard to how much permanent alimony he will be willing to give as a one-time measure. List again after vacation.
After vacation.
List again. Give a date. List again on 21/7/26.
Must oblige.
You also have your instructions somewhere, it says in language.
Madam, in this regard, is affidavit is necessary from my side, you know?
That is what the law says.
Is it? Let him file, my lord, affidavit.
You have your instruction on that.
No.
It's prolonged.
My instruction, my lord, even one thing, my lord, my land before I'm saying, my lord, today morning I talked to her, my lord. Even my son is for higher studies, my lord, for MBA discourse, but still unable to go for higher studies of my son. This is the situation I'm facing right now, my lord. So therefore, my son is requesting, why not you join to stay together? My son insisting, my lord, because he's suffering in his studies, my lord. This is situation, my lord. That's all.
Yes.
Lordship, there are battery of lawyers in the Eastern Cities matter. I don't know whether all are represented. Mr. Jade Kamar is there, then SC Biswas, his name is also there.
May I please your lordship, my lord, we have a bail application, my lord, for accused Nirmal Pal, my lord. He has been detained since the date of judgment, and 8 accused persons were there, all the released on bail, my lord, except this person, my lord, Nirmal Pal.
Others were released on the ground of juvenility and old age.
Juvenile is some,
This
three
person
person
is there.
juvenile,
Every
juvenile,
time the matter comes, my lord,
and other 5
Lordship make the submission. Two, my lord, his client is only there, but others are on the ground of juvenility as well as on the ground of age. They were released by this honorable court.
Yes, ma'am. But this person,
It is one judgment. A lot of accused persons. How many accused persons are there?
There are lots, my lord.
8 accused persons, my lord. 8 accused persons convicted, and 7 accused persons are released on bail, my lord, except this person, my lord.
8 convicted. How many appeals are pending? 8 appeals.
Yes, my lord.
Four appeals.
4 appeal.
4. 4 appeals. 4 appeals. Okay. 1, 2, 3, 4, 5, 6,
Our appeal 50, my lord.
7. One, two. 8 have been convicted,
Yes.
or 7.
All seven accused persons already been released on bail, man.
No. How many convicted?
8 persons.
So, but only 7 persons have come in appeal, isn't it? One is missing. Is a case of what? 302.
302, your lordship.
Ms. Bhuya, you have filed your objection to the IA.
We have filed,
You have filed.
my lord.
Oh, yes.
Lordship, allegation against the present applicant is that he injured one of the deceased. Two persons died with a weight, your lordship. And PW4 witness accused Nirmal Paul along with other accused person. Milo? Life. Life.
Life.
Sentence, let us see.
Life in prison.
Life. Only on the ground of juvenility and old age.
All around well.
Present person, yes.
Judgment was 2016. During trial, you were in jail
Yes.
or in bail? During the trial?
During trial, he was on bail, my lord. He did never violated the terms and conditions of bail during trial of the case. And he regularly attended the court. And thereafter, my lord, considering the all aspects of the matter, as the all other 7 accused appellants were released on bail, except these persons, that aspects may kindly be considered. With certain conditions, he may be released on bail, my lord. Till final hearing of the appeal, my lord. He is in jail about 10 years, my lord.
Parity will not come in the instant case, your lordship. Lordship will kindly consider the merit of the case. In the merit, I don't think they have a good case because eyewitnesses specifically named the instant appellant along with others who have been released on bail on the ground of juvenility or old age.
You have a copy of the bail order
Lordship.
in respect of the others.
We have annexed the bail order in our petition, my lord. Your lordship will find
Page?
your lordship will find
Page 16.
page 13, my lord. Waterfall Porimal Pal, my lord. Page 12, my lord.
Hare Krishna, Sanju and Parimal, they have released on bail on the ground of juvenility, my lord. Page 21 of the IE. And your lordship will kindly see page 14. Lordship, page 14, para 4. On considering the age of the applicant number of Pratap Paul to be approximately 91 years, and as he has been in judicial custody for the last 9 years, we are of the view that the applicant number Pratap Paul should be released on bail. Accordingly, so and so Pratap Paul is released on bail. So on the ground of old age, he was granted bail. My lord, wait, may I see, wait. Let us see, my lord. This one is- Yes, yes, page 269 of the paper book, one weight of 2 kg. I have serious objection is against granting of bail to the instant applicant, your lordship.
Ninety-one years, Nalsa scheme and all that.
Yes, ma'am. So he doesn't fall into that category.
What is this age of this present applicant or the appellant?
Kiman age of Puna client, no? Puna client age to Kiman,
43.
only 43.
My lord, long detention may kindly be considered as the other accused person, 7 accused appellant already been released on bail, my lord. And we have got a decision, my lord, of the Supreme Court, my lord.
Yes, what decision?
My lord, if your lordship permit us, we have submitted.
That's it. Lordship, but while granting bail, your lordship has to see whether they have got a prima facie case. Your lordship will not go into the merit of the case, my lord, in detail. But whether they have got a prima facie case, they are seeking parity, but parity will not be applicable. Yes, yes, my lord. 10 years detention, but in the instant case, hearing has been taken place for number of times, your lordship. Number of occasions. It's not that, my lord, like the court did not take up the matter.
Appeal is of the year two thousand
Last 10
sixteen.
years. ma'am.
Yes.
He has been.
So are you
detained above 10
hearing be
years.
fixed as a lordship? This matter will be taken up, may be taken up, my lord, for hearing, at least his case, my lord. True, your lordship. Yes, but your lordship, others probably may not have so much of interest because they are granted bail, most of them. The
That is
series may
why-
come up, lordship may be taken up in a fixed date, your lordship.
If others do not be interested in pursuing the appeal, we cannot hear.
Too early, at the earliest, my lord, why they have been granted bail, my lord.
Therefore, the next step also, they will be here, they will not take it. How does that work?
And whether it is the fit case to grant bail, your lordship has to judge that time. Whether this is a fit case. That is his submission, I have not gone through the records of that.
No, during trial, he is in.
It was on to that the trial. So during the trial. I have 10 years of it. Now the matter is not being approved, one reason or the other, we are not taking. It's not being.
And
This is what he has given the Supreme Court. That is all we are.
We are not aware of whether in that judgment, nothing has been reflected as the penal provision, under what section they were. I didn't find it, I didn't, lordship.
basically it's a length of incarceration.
Yes, my
It's
lord.
ranging from 10 years to 17 years. Now, my brother has pointed out, submitted by the appellant's counsel. During trial, he was on bail. There is no, bail conditions were not violated. The appeal was filed in 2016. Today we are in 2026, 10 years have passed by. And thirdly, the application for suspension of sentence, how many times you have filed? Suspension? How many times have you filed?
Agote I filed person, no?
No,
One.
earlier one application was filed, my lord.
Which
It was rejected. Was it rejected?
Yes.
Rejected by
At
which
the, at
means?
the initial stage, my lord.
Lordship, I have to see then on which bench is rejected, then it has to be placed before that appropriate bench.
My lord, there is.
No, no, see, the simple thing, we have to see, we have to open up things.
Sorry.
Because I was little surprised, because 2016 you have filed the appeal.
Yes.
And so all these years you have kept quiet about the suspension of sentence. Now this IA is filed in 2025.
Yeah.
After 9 years you have filed.
Yes.
So, but now you admitted initially you filed one application also. So how it was looked into? That has to be recon. And I don't know whether it has to be the same court or otherwise.
Has to be before, if available. Then.
Nirmal Pal.
I come to the 57. Well, none of them, Lordship may take up. 9/3/2021, Honorable Justice Suman Shyam and Mir Alfaz Ali. Oh, this is as regards Sanju Paul. Lordship may, Nirmal Paul, another.
You have not made any statement here in your application that you had come for suspension earlier also.
Lordship, in an order dated 9/3/2021, after a careful examination of the LCR, we find that there is sufficient evidence against the applicant number 1, Nirmal Paul. Therefore, the bail prayer of the applicant stands rejected. Suman Shyam.
IA 1719, I think.
457. Honorable Justice Suman Shyam and Mir Alfaz Ali.
Who was the applicant?
Here, two applicants were there. Nirmal and Sanju Paul.
Presently, the applicant is Nirmal.
Nirmal
Paul.
Yes, which the bail application was considered, and Honorable could observe that there is sufficient evidence against applicant number 1, Nirmal Paul. Therefore, the bail prayer of the applicant stands rejected. This is in the year 2021.
This is public fear.
I see. Lordship, another application I found.
Oh, how many applications you filed?
1719.
I think it's more than one. It's more than two. 1719 is
Yes,
also there.
that is also there. His case was rejected. Nirmal Paul and another.
It says, according to the prosecution case, applicants along with co-accused persons after forming unlawful assembly, common object made murderous assault on so and so. Crime was committed most brutally in open market, but which created terror. Co-accused Siva Paul even pierced the devil. Eyewitnesses have categorically testified the applicants have actively participated in the commission of gruesome crime. Their evidence is also substantially corroborated by the prosecution examination. This was the ground for rejection. Right.
Twice considered and rejected, madam. Let the entire matter be taken up for hearing. It's coming for hearing. Today it has also come up for hearing.
But you said the others may not be interested.
Yes, my
They've
lord.
got the
I
bail,
observe
so-
from the lordship may not be interested because
All right.
others. But his cases were considered twice, my lord. Today on the third occasion they have come.
16. Some other person had stuck the dagger inside him. Therefore, the bill was rejected for. The other is that that he gave the final, he gave the those who the final was never good. It was not good. And we should say different persons gave the.
But this is a case of 34, 30 to 34, then common intention, my lord, everybody would be liable.
Yeah, 34 this man would have gone for.
My lord.
Now, since 34 is there.
My lord.
Two times it has been rejected. This is what is holding us back.
My
Next 10 years, even with this two different persons being named of hitting with the weight. And when the child court himself said later on that they did not act as if they wanted to attack anybody or anything. They left those persons who were trying to take the victim. If they hit someone who's coming and helping the victims, they will not attacking the victim again. They let it go. So the intention was to strike back at one particular. They hitting the left. All others are on bail. Maybe 43 years, neither on the criminal side nor on the overrated side is only inside. That is what is considered. And whatever you have stated is what is building up.
We'll take 5 minutes break and come back.
Lordship, may I pray, this matter may, all the matters may come off on a fixed date for hearing. Your Lordship may please to observe. No adjournment will be given on that day, and the matter may be fixed, may be taken up and disposed of.
They're all fixed.
That is my one prayer. Alternative prayer is this matter may come up day after tomorrow. I'll come up with judgment, which is,
My
I may found something
maybe my lord, our
on
prayer
length of
is
detention.
granting
Make
bail.
it-
If there is no chance of his absconding, to avoid that if he is convicted. Okay,
Or on Friday, your
We'll,
Lordship.
we'll do one thing, we'll fix a date.
we have submitted some other.
We'll fix a date for hearing of the appeal. Appeal itself, will fix a date for hearing.
Yes, my lord.
Now, for one reason or the other, if appeal is not heard, it'll be open for you to raise, to press the IA for release of bail. That observation will,
It is pending from long day.
we have seen one observation of November 2025. But thereafter, everyone was taking adjournment, prayer of the parties. So, we'll do that. Give us a date. After vacation. 16/7.
Come on, get sentence to assembly.
What is your good name?
And Ahmed,
N.
Nazimuddin Ahmed. And Ahmed.
Mr. N. Ahmed, learned counsel for the appellant in criminal appeal number 50 of 2016. And also for the applicant in IA criminal number 1154 of 2025. Submits that the applicant may be released on bail pending final consideration of the main appeal. Stop. He submits that all the other accused have been released on bail for one reason or the other. And therefore, applicant may also be given the benefit of release, of being released on bail. Next param is B. Boyan, learned senior counsel and additional PP, submits that the others were released on grounds of juvenility and because of all age, whereas the state applicant is in his mid-40s only, and that he had a major role to play in the crime. Stop. She also submits that the applicant had earlier approached this court with similar application on had earlier approached this court on 2 occasions with similar applications, and both the applications were rejected.
Lordship, may I leave your lordship to another one?
Please
So
go.
sorry.
Stop it. May have we seen that despite rejection of the applications earlier, the applicant has spent around 10 years in jail. And that prior to his conviction, he was said to have been released on bail during the trial. Next paragraph, upon considering the above projection, we deem it appropriate to pose the matter for hearing. On 16/7/2026. Stop if for any reason, the bail up, the appeals are not taken up for consideration on that day. The petitioner, the applicant would be at liberty to press the application seeking for suspension of the sentence. Anyone else is appearing for the appellant apart from you?
Service hearing.
On the IA. What about the other appeals? The other appeals, anyone else?
Yes, I'm
Okay,
on bail, my lord. Merit, it was.
you're on bail.
Was no one motive, nobody has implicated me, my lord.
Ah.
Or I was named in the FIR, my lord.
So we're fixing a particular date for hearing. Otherwise, the
understand.
bail application will have to be considered.
There is evidence of one or two witnesses, my lord, but still others have get the benefit, my lord.
There's one more matter left.
Lordship, they want adjournment, lordship.
Which matter?
Wait, please, your lordship. Lordship senior is having an having a dental appointment, lordship. On his way, will take hardly 25 minutes.
In which case, supplementary.
Lordship, in 22.
Who is the counsel? Mr. Chaudhary,
Senior BD Core.
BT Kaur. He's there in both the appeal as well as the IA.
Yes, your lordship.
And state,
Lordship,
you are there.
Bibua is there, lordship. She is going to, she have gone through the case, lordship.
Yes, your lordship. He's on his, if he's right now in a before
his
the
way.
dentist, your lordship. He'll reach in.
He is
12,
still in the
15,
chamber
20
of the
minutes.
dentist. He's in the chamber of the dentist.
On his way.
Ah.
On his way.
You cannot say about.
But can he submit with after visiting the dentist? You may be having problem.
He's having a toothache since this morning.
Has been informed that if the adjournment is not granted, then he will reach in 10-15 minutes.
If not granted.
If it's the adjournment is not granted, your lord.
He may not be the best of his, what do you call, he may not be comfortable
Yes, maybe.
after visiting the dentist. That's what we are thinking.
After vacation.
Is there any urgency in the matter? Otherwise?
If your lordship is fixing a date, can it, after vacation?
When do you want it?
After vacation?
3-0.
13 to see appeal in the next paper. 21. 17.
Okay.
21st July. Yeah.
21st, okay. As agreed to by the parties, this is the matter for hearing on 21st of July 2026. There are two appeals, let me explain. Send this to your chamber. And along with that, I will correct the order. We'll listen together. This was item number 4. Oh, we can pass one order now. 6. And along with that's 1-4.
I found that the two appeals have been filed by the same person. Mr. D.K. Bhattacharya, he is appearing in the other appeal, my lord. Separately, my lord. D.K. Bhattacharya, his case number is criminal appeal 114, ours is 121, my lord. Just a day or two, after
So,
a day or two.
Two appeals by one same person.
Same person, my lord.
What is to be done then?
We will withdraw, my lord. Since ours is subsequent, my lord. But my lord, appellant,
We'll list this matter together on some day.
already listed, my lord, I think,
On?
together.
I think.
On 23rd of, it is fixed on 23rd of July. Item, criminal appeal 114, that is fixed on 23rd of July.
Acha, this criminal appeal 114 is fixed on 23rd of July.
23rd of July, my lord. I have checked, my lord. And I had a talk with Mr. D.K. Bhattacharya also. He also said, yes, it seems to be the same.
So on that day, you make the submission.
Lordship.
Please write one order, item number 6. It appears that the appellant has filed 2 criminal appeals. That is criminal appeal number 121 of 2026 and criminal appeal number 114 of 2026. Now it is further submitted that criminal appeal number 114 of 2026 is scheduled to be listed on 23/7/2026. So therefore, let this appeal be listed along with criminal appeal number 114 of 2026. This is item 6 of it. There was only one order I did. Replace that this one.
Obliged.
May it please your lordship, sorry for the inconvenience, lordship, in regard to item 22, the matter is fixed on 21st of July. Can it be on 20th, 20
2-0.
of July?
Please bear up. Wait, please, Monday. Okay, make it. Did you take the order? Oh, okay, this is item 20. Instead of 21, it will be 20 of July.
Obliged.